I can't tell you how many times people will come to my office and tell me that they don't have to worry about overtime or the Fair Labor Standards Act because they pay everybody a 1099 and therefore they're independent contractors. Let me tell you, that is a huge mistake, because what that ends up doing is you are misclassifying potentially employees as independent contractors, and therefore you are setting yourself up for a huge Fair Labor Standards Act violation lawsuit, which could cost you tens of thousands of dollars. So how do you avoid that? Well, you know the difference between an independent contractor and an employee, and it's way more complicated than simply whether you pay them a W-2 or a 1099. There are, depending on whether you are in federal or state court, between 6 to 10 different criteria that a court will look at to determine whether somebody is an employee or an independent contractor. The federal and the state classifications tend to have some overlap. They are somewhat similar. It pertains to whether or not those people are in business for themselves, whether they have their own tools, but the largest factor is the degree to which the employer has control over the employee. And the problem is, if you misclassify them as an independent contractor and they work more than 40 hours per week, a court can look back 3 years and you would have to pay them for past due overtime for 3 years, plus an equal amount in liquidated damages, plus that person's attorney's fees. So a very small underpayment can have catastrophic consequences.